Okay, let's go on the record on cause number DC 21-10028. Erica Bali versus Travis Kyle Cadell. Counsel, make your appearances.
My name is Eric Douglas, and I represent the plaintiffs.
This is Monica Batak, and I represent defendants Travis Caudell and WHW Transport.
And is there another set of defense attorneys, or has that been taken care of?
Yes, Your Honor, there is another set of defendants. It's Jose Ibarra and Roca Trucking. They're represented by Jerry Alcantara.
Are you expecting him to be here for this?
I would have expected him to be, but I don't know for sure.
Okay, well, let's go ahead and proceed. And if he shows up, he shows up.
It's hearing because
Mr. Douglas, you're cutting out. Can you say that again?
Your Honor.
Can you hear him, Ms. Batik? I can't hear him.
No, Your Honor, I can't hear him.
I can't either.
Okay, so I've been having problems with my computer today, so maybe that's, I was just wondering if it was mine or his. Mr. Douglas, can you try? Yeah, I can't hear you. I'm not sure. You may want to sign back on or use your phone or something. Ms. Batik, can you hear him?
No, Your Honor, I still can't hear him. I can hear you just fine, though. Can you hear me okay?
Yeah, I hear you fine. I heard Tony fine. Are you signing on to Jerry PC right now, Mr. Douglas? I still can't hear him. Mr. Douglas, are you signed back on? Can you start your video? Mr. Douglas, are you there?
Can you hear me now? Your
Yeah.
Honor. All right.
Okay, let's get started.
Okay, so I requested this agreed. We filed an agreed final judgment, and we noted on the court's website a hearing was requested. And I'm assuming it's because
All right, let me kind of explain that. I don't know. You want to distribute the funds from the settlement directly to the parents as opposed to the child, and I just don't allow that unless there's extraordinary circumstances. So that's the situation.
Okay, well, that's fine. We can certainly do a minor settlement hearing. The only reason that we initially didn't do that procedure was the mediator had advised that he corresponded with you, and you said that it was okay to not do a minor settlement because the amount was so small.
How much is the settlement? I thought it was $2,500 to the kid.
It's $2,500 to 2 children. Yes, Judge. And then after paying the medical providers, it ends up being $846 and $496.
Oh, I thought it was $2,500 to each child in their pocket. Okay, I misunderstood. On settlements, what are the injuries?
So each child was taken to Baylor Emergency Room. One of them had an abrasion and was given ibuprofen and had no further treatment. The other child, who was 4, said that she had a stomach ache. She didn't require any further treatment other than she was checked out by a chiropractor and said that she had no further injuries. And that was the next day after the accident.
Okay, so I'm looking at the agreed final judgment. It says $2,500 will be paid by defendants by check to Adriana Guillejos. So the total settlement is $2,500. That's not the amount that's going to the parents.
Yes, Judge.
Okay. All right, I'll go ahead then and approve this. I thought it was $2,500 a piece to the kids. All right, that sounds good. I'll go ahead and sign that and get that in today. And just in the future, just realize if it's typically a significant injury or 5,000 or more in settlement, I typically will have a minor proof up. So just kind of be aware of that.
Yes,
All right,
sir.
guys, have a great rest of your day.
Thank you.
Thank you.
Thank you. All right, is everyone here for the 2:30 hearing? We're
I'm
still waiting on anybody.
Plaintiff's attorney is present.
Okay. We're still waiting for the other side.
Correct.
Okay. All right, no problem. Are you here on the rapid care case?
Correct.
Okay. All right. Mr. Barron, can you hear us?
Yes, sir. Yes. Yes, sir. 1 second. Can you hear me, sir?
Yes.
Okay. You need my video on?
Yes. All right, Mr. Barron, can you hear us okay?
Yes, sir.
All right, let's go on the record, Tony, on DC 218362, Rapid Care Emergency Room, Katie Mason LLC versus David Barron and Universal Medical Systems. Counsel and parties make your appearances.
Javaria Sayed, attorney for Rapid Care ER.
Your Honor, I don't have an attorney yet. I had one, but he withdrew.
Okay, so state your name for the record then.
David Barron.
All right. Okay, Ms. Saeed, if you want to go ahead and proceed.
Yes, this is a motion for cause, to show cause for why he hasn't complied with the order that was signed, I believe back in, I believe it was back in April of this year, to produce disclosures. And I've contacted him, emailed him, and I've not received anything. And so it's a motion to show cause for why he hasn't complied with the court order.
Aaron, have you not complied with the court order?
I've received it, but like I said, I haven't been able to afford or retain counsel, so I don't know what to do here.
So, Mr. Barron, as I understand it, they've sent you some questions you need to answer. Ms. Said, am I correct that there's a judgment against Mr. Barron? Is that right?
There is a court order compelling him to answer the disclosure. So it was three things. It was I need documents. I was asking for documents, denials and admissions. And there was one more request for interrogatories, and I haven't received those yet. That was due back in April, and our trial date is in a couple of weeks. I've given him ample time to find an attorney and to answer these questions, and I've not received anything.
So, Mr. Barron, let me kind of explain what's going on so you kind of understand. So, the other side has sent you questions, which they're allowed to do under the rules of civil procedure. You have an obligation to answer those questions. They ask me to order you to do that. I have done that. You've been ordered to do that by the court. And now the situation is that you haven't answered that despite a court order. And so you might think to yourself, well, what's the big deal? You may not have money to pay for a judgment, or you may not, I've had people in the past who said, well, what's the worst thing can happen? Well, because you're in violation of a court order, I'm put in a very difficult spot, because there are two things that I can punish someone with when they've violated a court order. I can put you in jail for up to 6 months, and award up to a $500 fine per violation. Of course, that's not what we want to do. No one wants to put you in jail, but you can't just disobey court orders. Does that make sense, Mr. Barron?
Yes, sir.
So, go ahead.
Yes, sir. It does now.
Okay. So you need to answer those questions, whether you have an attorney or not. If you fail to answer those questions, then you could be found in contempt, and the court could order you to go to jail for up to 6 months and up to $500 fine per violation, which again is the last thing that anybody wants. Do you still have a copy of those questions that were sent over to you?
Yes, I have them from I'm trying to look them up now. Because I believe the opposing counsel sent them directly to me.
Some what?
I believe Ms. Said sent them directly to me.
Okay.
Or did you send them to Mr. Zislow?
I've sent them to you and to Mr. Brian.
Mm.
And I can certainly send them back over to you again.
Okay. I'd be happy to fill them out. Like I said, I will fill them out and get them over to you, sometime today.
Okay.
Didn't realize there was a court order. That's the
There's
reason.
a court order back on April 18th on this. Is that correct, Ms. Said?
Correct. And I emailed him the court order, I think a couple of times, which is attached to my motion as well. It's on page. Yes, it's on page if they're not numbered, but yeah, it's on page, I believe, 39. I sent it to him and I attached the court order.
Is there a way you could send those questions over to my personal email?
Is it that the MRI guy 33?
Yeah.
Yeah, I've sent them to that specific
Okay.
email.
Okay. So I have the motion for continuance, the notice for hearing, and the motion to get set.
Okay, so you're requesting him to pay what in attorney's fees? What is your request?
The request for attorney's fees was, I believe, around 2,000 for this motion, and the exhibits.
All right, so you're going to be ordered to pay attorney's fees, and then I'm going to give you until Friday to answer this.
What's the name of the answers that the attachment? This side.
I apologize, I didn't. Can you repeat that?
What's the I have several emails from you. I'm trying to figure out which one has the.
Ms. I just resend them the questions to after this hearing's over.
I sure will.
So, Mr. Barron, let me just kind of explain. So you're going to now owe them $2,000 for violating the court order. And then for each day after this Friday that you don't get them these answers, then you're going to owe them an additional $500. So you have until this Friday to answer them. I'd encourage you to get an attorney. You do have a trial setting coming up on October 11th. And so you want to try to get counsel as soon as possible.
I'm trying, ever since this has been tied up in legal, I'll try my best to get someone. I had one, he kept wanting more money. I paid him $5,000, I think, and October 11th is the hearing, and then have by Friday.
Yes.
Okay, I'll get it done.
Okay. All right. I'm going to sign the order. I've amended it a little bit. Ms. Said, it should be, and Mr. Barron, it should be on the court website by tomorrow. And Ms. Said, make sure you send them a copy of this order as well.
I sure will.
Okay, you guys have a great rest of your day. Mr. Barron, please comply with the order, or things will just get worse if you don't, okay?
I will.
All right, thank you so much. You have a great rest of your day.
Thank you. You too.